Number 12. So, Lordships, this matter may pass over for today and kindly fixed after the vacation. There are some personal difficulties and space for time.
This will go after vacation.
Yes.
Prepare the concept. Yes.
Your Lordship, I beg to mention item number 14, Your Lordship. Lordship, this matter also may be taken after vacation, Your Lordship. I have taken the consent from the respondent side. I am for the petitioner, Your Lordship, on behalf of Mr. S.T.K.
21.
Lordship may be taken after vacation, Your Lordship.
Come on. Yes.
Lordship, kindly the matter may be taken up at 2 p.m. Lordship. Lordship, the conducting counsel, he is on legs in court number 2, Lordship.
Take it after some time.
Address, Lordship.
May I please, your Lordship? Lordship, this matter may be passed over for the time being, Lordship.
What is this timing business?
Lordship, Zay Ahmed is coming, Lordship. He is on the way.
Day after tomorrow. Yes, ma'am.
Lordship, may I pray for an adjournment today, Lordship, in this matter?
Why 2016 matter? What's the reason for adjournment?
Oh, Lordship, may pass it for the time being. Mr. Akiri Chaudhary is on legs in some another court, Lordship.
2016 matter on the last occasion also.
Lordship, time being, Lordship.
Oh, stay here.
Time being.
Will be arguing the case.
Lordship, Mr. Akiri Chaudhary will be arguing, Lordship. Time being, Lordship.
After some time.
4. I will have it after some later. the next.
Lordships. In this case, my Lordships, father and mother, as witness number, OPW number 2 and 3, they adduce evidence, and village headman and school master also examined. Besides the OP. No rebuttable evidence adduced by the state. Linkage, 5 linkages given. Voter ID, school certificate, PAN card, voter list, and village admin certificate. 5 linkages.
Mr. Sharma, by an order of 29th of March, the Superintendent of Police Border Dorong as well as the Superintendent of Police Border Nalbari were directed to submit a verification and inquiry report. Do you have a copy of the same? Let's take your seat.
Latest NRC also available. Father and mother. Lordship, there is no cross regarding that the father and mother is not due. No cross. Lordship, Counselor Ali is grandfather, paternal grandfather, and Hazrat Ali is maternal grandfather. Ali, maternal. Ibrahim Ali. Double. Lordship, I can claim citizen of
Come back to
India.
you. We'll come back to you.
প্রথমতে আছে 17
Read the order of the tribunal.
Lordship.
Read the order of the tribunal.
Order, Lordship. Mm. 69%. From the beginning, Lordship.
Read it.
The reference, this reference has been made by the Superintendent of Police, Border, Nalbari, under Section 2(1) of the Foreigners Tribunal Order 1964, on the ground that on being asked, the suspect OP could not produce any documentary evidence in support of his or her entry into India prior to 1966. Though he or she claimed to be a citizen of India, the named suspect not found in electoral roll of 1965 or 66. So it has been referred to this tribunal for opinion as to whether the opposite party, Muhammad Sonar Ali, son of Muhammad Ibrahim Ali, village Kasimpur Police Station, Nalbari, district Nalbari, Assam, is not a foreigner. On receipt of the reference, the case was registered before this tribunal and notice was issued to the opposite party. He entered his appearance and contested the reference by filing written statement denying the allegations made in the reference and claiming himself to be an Indian citizen. Since, as per the Section 19(9) of the Foreigners Act 1946, it is the burden of the opposite party to prove his citizenship. He was examined with reference to his claim, and documents have been scrutinized. Whether the opposite party is not a foreigner within the meaning of the Foreigners Act 1946. In his written statement, objections of opposite party stated inter alia that he is a citizen of India by birth and permanent resident of village Kasimpur, police station and district Nalbari. His father Ibrahim Ali, who hailed from village Boruajar, police station Dolgaon, district Dorong, married with his mother Fatima Bibi, daughter of Hazrat Ali, in 1981 at village Kasimpur, and after living there at village Kasimpur for a few months, he went to his place at Dolgaon. He occasionally used to come at village Kasimpur to meet his mother. Due to cruelty meted out to her by Opi's stepmother, she was not allowed to stay at his father's residence. His father was voter under 68 Dolgaon Legislative Assembly constituency since 1985. His grandfather Songsher Ali was also voter since 1951. His mother Fatima Bibi has been voter in village Kasimpur since 2011. His maternal grandmother, father Hazrat Ali, has been voter at village Kasimpur since 1965. The OP has been a voter under 61 Dharmapur Legislative Assembly constituency since 2013. He read in Kasimpur Primary School till 31/12/1997. The OP filed additional written statement where he stated inter alia that in 1985 his mother Fatima Bibi was enlisted as voter together with his maternal grandfather Hazrat Ali. Along with his written statement, OP filed photocopies of 1985 electoral roll showing the name of Hazrat Ali, Tusta Bibi, and Fatima Bibi. Electoral rolls 1985, 1987, 1966, village Boruajar, electoral photo identity card of Ibrahim Ali, NRC details of Songsher Ali of 1951, 1966, and 1971. Voter list of 2013, voter slip of 2011, electoral identity card of Fatima Bibi, NRC details of 1965 of Hazrat Ali, electoral roll of 1965 of Hazrat Ali, PAN card of Sunahar Ali, Fatima Bibi, electoral identity card of Sunahar Ali, school certificate dated 21/1/2011, certificate dated 22/3/17 and 26/4/2017 issued by Dipul Boro, Gaubura of village Kasimpur. In his evidence, OPW 1, OP deposed inter alia that he is a citizen of India by birth and permanent resident of village Kasimpur, police station and district Nalbari. His father Ibrahim Ali, who hailed from village Boruajar police station, Dolgao district, Dorong, married with his mother Fatima Bibi, daughter of Hazrat Ali in 1981 at village Kasimpur, and after living there at village Kasimpur for few months, he went to his place at Dolgao. He occasionally used to come village Kasimpur to meet his mother. Due to cruelty meted out to her by his stepmother, she was not allowed to stay at his father's residence. His father was voter under 68 Dolgao Legislative Assembly constituency since 1985. His grandfather Shangsher Ali was also a voter since 1951. His mother Fatima Bibi has been a voter in village Kasimpur since 2011. His maternal grandfather Hazrat Ali has been a voter at village Kasimpur since 1965. Dopi has been a voter under 60 on Dharmapur Legislative Assembly constituency since 2013. He read in Kasimpur Primary School till 31/12/1997. His mother Fatima Bibi was enlisted as voter together with his maternal grandfather Hazrat Ali in 1985. Exhibit 1 and 2 are certified copies of extract 1985 and 97 electoral rolls relating 68 Dolgao Legislative Assembly constituency, wherein village 1 or 2 Boruajar, 68 Dolgao Legislative Electoral Ibrahim, son of Shangsher, is 27 and 40 respectively are written. Exhibit 3 is certified copy of extract 1966 electoral roll relating to 73 Dolgao Legislative Assembly constituency, wherein village 1/2 Boruajar elector Shangsher Ali, son of Kosar Munshi, is 45 are written. Annexer 456 are NRC voter details of Shangsher Ali, son of Kosar of village 1/2 Boruajar for the years 1971, 66 and 51 respectively. Exhibit 7 is certified copy of extract 1985 electoral roll related to 61 Dharmapur Legislative Assembly constituency, wherein village Kasimpur voter Hazrat Ali, son of Torifullah, as 57, Tusta Bibi, wife of Hazrat, as 45, and Fatima Bibi, daughter of Ibrahim, wife or daughter of Ibrahim, is 25, are found written. Exhibit 8 is proved in original copy of electoral fraternity ID card of Fatima Bibi. Relation name Ibrahim, is 43 years, as on 14/12/2015. Exhibit 9 is proved in original copy of PAN card number so and so of Fatima Bibi, daughter of Hazrat Ali, date of birth 1/1970. Exhibit 10 is certified copy of extract 1965 electoral roll, wherein village Kasimpur elector Hazrat Ali, son of Torif, as 36, and Rustajan Musalmani, wife of Hazrat, is 30, are found written. Annexer 11 is NRC voter details of 1965 of Hazrat Ali, son of Torif, village Kasimpur. Exhibit 12 is proved in original copy of PAN card so and so of Sunahar Ali, son of Ibrahim, date of birth 1/2/1985. Exhibit 13 is proved in original copy of electoral photo identity card number so and so of Sunahar Ali. Relation name Ibrahim Ali, is 28 years, as on 1/10/2013. Exhibit 14 is school certificate issued 1/21/2011 by Muslim Ali, head teacher of Kashim Ali LP School, Kendekusi, Nalbari, to the effect that Sunahar Ali, son of Ibrahim Ali of village Kasimpur, studied in the school till 31/12/1997. Completion of class 4. His date of birth is 1/1987. Exhibit 15 is a certificate issued on 22/3/2017 by Dipul Boro, Gabura of village Kasimpur to the effect Shunahar Ali, son of Ibrahim Ali, and Fatima Bibi is a permanent resident of Kasimpur area. Exhibit 16 is a certificate issued on 26/4/2017 by Dipul Boro, Gabura of village Kasimpur to the effect that Fatima, daughter of late Hazrat Ali, is a permanent resident of Kasimpur area. Annexer A is the voter slip of Shunahar Ali of 2011. Annexer B is the voter list of 2013. Annexer C is a voter slip of Fatima Bibi of 2011. Annexer D is a copy of voter list 2013. During cross-examination, OP deposed inter alia that he was born in the year 1987. He has 7 brothers and sisters, namely Ombia Khatun, Saleha, Muhammad Ismail, Muhammad Alef, Ravani, Shonwara Begum, Muhammad Monwar and himself. Fatima and Aklima are his mother. Sultana Parvin and Yahibullah are his children. His father and 11 brothers and 9 sisters, namely Atab Ali, Bosiruddin, Helaluddin, Korim, Shoruz Ali, Nausad Ali, Dudu, Asad Ali, Murgub Ali, Tan Mohammad, Maleka, Hawa, Aklima, Fatima, Jorina, Joygun, Joinub, Rohima and himself. OP examined Fatima Bibi, wife of Ibrahim Ali and daughter of Hazrat Ali, as OPW2. She supported the evidence of OPW1 and the exhibits provided by him. Next 6. OP examined Ibrahim Ali, son of Shamsher Ali, aged 60 years, as OPW3. He deposed internally that Shunahar Ali is his eldest child. He supported the evidence of OPW1. Annexer E is the copy of electoral roll 2017. He further deposed that he has 2 wives, Aklima and Fatima. Aklima resides in Boruazar and Fatima resides in Kasimpur. He has 11 brothers and 9 sisters, namely Atab Ali, Bosiruddin, Halaluddin, Karim, Shoruz Ali, Dudu Mia, Nausad Ali, Asad Ali, Murgab Ali, Shan Mia, Maleka Rahima, Fatima, Hawa, Jorina, Hasana Begum, Aklima, Joinub, Joygun, and himself. Bibijan, Kanchan, Khatun, and Sahara were his stepmother. Suleiman was his actual mother. OP also examined Dipul Boro, aged about 40 years, son of late Shomin Boro, as OPW4. He deposed inter alia that he became Gabura of village Kasimpur in 2016. Exhibit 15.3 is a registered maintained by his father in 2005. Where at serial number 76, the information related to OP is written. The entry were not written either by his father or by him. It is not written in the register from which date the OP and his family started residing village Kasimpur. The register is in torn condition and the pages are not in order. OP also examined Muslim Ali, aged about 50 years, son of late Baju Ali of village Kasimpur, as his OPW5. He deposed inter alia that he issued Exhibit 14 certificate as headmaster. He issued the certificate on request of the villagers and Fatima Bibi. He did not brought admission registered or any other records of the school. I have heard arguments of both sides. As per police verification report, Muhammad Shunahar Ali, son of Ibrahim Ali, and husband of Akiman Bibi, a resident of village Kasimpur, police station and district Nalbari, could not produce any valid document in support his nationality, and so he was suspected to enter into India illegally after 25th March 1971. On careful scrutiny of the above, it transpires that OP has not been able to show his linkage with Fatima Bibi, daughter of Hazrat Ali. Annexer B and D are mere photocopies which cannot be accepted in evidence. OP has not been able to show any document that he is related with Ibrahim Ali of village Boruazar onto Boruazar police station, Dalgaon district, Dorong. In spite of the oral evidence of so many witnesses, the linkage of OP with Ibrahim Ali of village Boruazar police station, Dalgaon district, Dorong, could not be established due to want of linked document. As a result, the OP has not been able to prove his linkage with Ardar Ibrahim of Exhibit 1 or Fatima Bibi of Exhibit 7. I am therefore of the opinion that OP has not been successful to prove his citizenship from the relevant period. He is found to be in India illegally on or after 25th March 1971.
Okay.
This reference is
But
disposed of
let's
by
leave it there,
answering.
leave it there, leave it there. Now please come to page number 32. Read the evidence of the Gambura.
32. Yes, my lord.
Read the evidence.
Exhibit 15 is my certificate. Chamin Boro Kasimpur, village admin. Exhibit 15 is my certificate issued on 22nd/3/2017 to Muhammad Shunar Ali, son of Muhammad Ibrahim Ali, and mother Mosammat Fatima Bibi is the resident of village Kasimpur, Mauja Notun Dehor, post office Kendagusi, police station and district Nalbari. Muhammad Shunar is permanent resident of village Kasimpur area. I know OP Muhammad Shunar Ali from my childhood. Exhibit 15(1) is my signature. Exhibit 16 is my certificate issued 26/4/2017 in respect of Fatima Bibi, daughter of Hazrat Ali, and mother of OP Muhammad Shunar Ali of village Kasimpur under police station and district Nalbari. She is also permanent resident of village Kasimpur. I know her since my childhood. Exhibit 16(2) is my signature. I issued certificate on the basis of register. Exhibit 15(3), serial number 76. The register is maintained. She is my father. I became Gavura of village Kasimpur in 2006. The register is produced today, and the entry at Exhibit 15(3) is shown before this tribunal. The entry are not written by my father and or me. The register is maintained since 2005. I have not maintained any page number of this register. The entry in register as Exhibit 15(3) is written after 2005. I appeared as witness in some other case before this tribunal. I did not show any register or records previously before this tribunal. The entry was made on the basis of personal knowledge, not based on any records. It is not written in the register from who is that. The copy, now OP and his family are residing in village Kasimpur. I do not know why the register was written. The register is in torn condition and the pages are not in order. The register also does not contain any certificate. I do not know my father has done Hatshita or not. I do not know about Hatshita. I cannot say about the new entrance in the village, births and dates of villagers. I do not know whether the entries made in the register were genuine or not.
So this Gambura was a witness to this to prove the citizenship of the petitioner. Clearly stated in his cross that the certificate that he has given or the entry that was made on the basis, it was only because of his personal knowledge, not based on any record, right?
Right.
He has given his personal knowledge.
But he know them
We are
from his
not on-
childhood.
He might know that it is personal knowledge. He have written the fact that he has given it his personal knowledge, not on basis of any records, right? And also he is the fact that that entry that was made was neither by his father nor by him. And also doesn't know when the register was written. Now, come to page number 33.
It is Muslim Ali. Teacher, head teacher. Exhibit 14, certificate issued to Shunar Ali, son of Muhammad Ibrahim Ali of village Kasimpur, police station, district Nalbari, was issued by me as headmaster on 21st/1/2011 Kashem Ali LP School, Kendakusi, as the certificate Shunar Ali passed 4 in 3rd division in the year 31/12/1997. 14.1, Exhibit 14.1 is my signature. I had crossed. I was headmaster of Kashem Ali LP School from 1996 to 19 June 2011. Mosammat Fatima Bibi, aged about 50 years, daughter of Hazrat Ali, was my neighbor in village Kashimpur. The first wife of Hazrat Ali was Kusto Bibi and second wife was Shokina Bibi. Fatima was born in Kusto Bibi. Fatima Bibi was born of Kusto Bibi. Fatima Bibi was first married with Muhammad Bilal Ali of village Kasimpur. Fatima Bibi left her husband after about 9 months. Fatima Bibi remarried with Ibrahim Ali about 1 year thereafter. Shunar Ali, Munaf Ali, and a girl were born out of wedlock of Ibrahim Ali and Fatima Bibi. Ibrahim had a first wife at Dolgao and Mongoldoy district, under Mongoldoy district. Fatima Bibi also went there, but after 3 days, she was forced to return to village Kasimpur. On the request of villagers and Fatima Bibi, I issued Exhibit 14 certificate. Though Ibrahim Ali was residing occasionally at Dolgao, and he insisted to issue the certificate giving the address of Dolgao. I have not brought admission register and any other records of the school today before this tribunal. It is not a fact that Exhibit 14 was issued falsely. I consulted Gavura at that time of issue of certificate.
Please come to page number 34.
34. This is to certify that Shunar Ali, son of Ibrahim Ali of village Kasimpur, PS Nalbari, subdivision Nalbari, district Nalbari, studied in this school and completed his study on 31/12/1997. He passed class 4th examination and secured 3rd division. His conduct and character was found good in this school. As per school register, his date of birth is 1/1987.
Now please come to page number 62 or 61.
61. Another certificate given by Dipul Boro Gavura. Certificate. This is to certify that Shunar Ali, son of Ibrahim Ali, and Mosammat Fatima Bibi of village Kasimpur, post office Kendagusi, Mouja Notundehor, PS Nalbari, district Nalbari, in the state of Assam, is a resident under my lot. He or she belongs to permanent resident of Kasimpur area. I wish him her very well. Dipul Boro, Lord Gavura.
Then page 63.
Another certificate, Dipul Boro. This certificate, this is to certify that Fatima Bibi, daughter of Hazrat Ali of village Kasimpur, post office Kendagusi, Mouja Notundehor, PS Nalbari, district Nalbari, in state of Assam, is a resident of under my lot. He or she belongs to permanent resident of my Kasimpur area. I wish him or her very well. Dipul Boro, Lord Gavura.
Now please come to page number 62.
60. 62 is vernacular.
That's why we're asking to.
Shunar Ali,
Don't go to that. Last two
Pramantra to
lines.
the
Last two lines.
last line. কেউ মোৰ লাটৰ বাস কৰাৰ লোক হয় আৰু মই ভালদৰে জানো।
Read the English. He, she. Next line.
He, she is belongs to permanent resident of Kasimpur area. I know him or her very
After
well.
Kasipur area, what is there?
Kasimpur area, Bahindar. Babe.
So this certificate was issued towards the purpose of what? That to show that Sunahar Ali is a resident of Kasimpur
Kasimpur.
area, right? Now please come to page number 64.
প্রমাণপত্র দেওয়া হল যে মিস ফাতেমা বিবি ওয়াইফ অফ হজরত আলী গাঁও কাশিমপুর মৌজা নতুন দেহর ডাক কেন্দ্রগুচি থানা জিলা নলবাৰী এও মোৰ লাটৰ বাস কৰা লোক হয় মই ভালদৰে জানো।
Then for what purpose you have issued this
নেক্সট
certificate?
বিষয় কাৰণটো কাটি দিয়া হৈছে।
Why? Why? So this is on what basis?
It is for জন্ম মৃত্যু বেংক একাউণ্ট।
For what basis you have issued this certificate? Why the Gaubura issued this certificate?
As a resident of that area.
It is nothing, no proof. He did not mention the reason for issuance of that certificate. Now, you have seen this evidence. Where is the illegality of the tribunal when the tribunal came to the finding that the proceedee failed to establish that he is the son of Ibrahim Ali of
বড়বাজার। One and two বড়বাজার।
That's right. He is the son of 1/2 number Boruazar village of West Dolgaon Moja, Mongoldoy subdivision, police station Dolgaon, district Dorong. Is there anything wrong on that part? Because no such evidence could be placed before the tribunal, documentary evidence to
The
establish.
father and mother themselves prove
See, that's what
that
we need.
their son is Sunahar
That
Ali.
is the reason. Tell us, where is the linking document to establish that you are the son of Ibrahim Ali of village 1/2 number Boruazar of Moja, West Dolgaon, police station Dolgaon, subdivision Mongoldoy, district Dorong. Or you have reduced any such evidence, documentary evidence to establish this fact that you are the son.
Voter ID, electoral identity card, PAN card, school certificate, voter list.
His school certificate is not proved because the register was not brought. Gaubura certificate not proved because the register himself stated he doesn't know. It was not entered, the reason for entering the date on which it was entered, and that he doesn't know who has entered it, neither he nor by his father. Your submission is as because one Ibrahim Ali and one Fatima Bibi, allegedly father and mother of the proceedee, have adduced evidence is sufficient to prove the proceedee to be an Indian citizen. That's your view, right? Good. Please take your seat.
My father and mother not foreigner.
Understood.
Lordship, I am citizen of India by birth because my date of birth is before 3rd July 1987. If my birth is before prior to 1/7/1987, then I may be declared as citizen of India by birth, as per Section 3 of Citizenship Act. Citizen Act. Except as provided in subsection 2, every person born in India, suppose B, on or after the 1st July 1987, but before commencement of Citizenship Act 2023, either whose, no, first one, on or after 26 January, but before 1st July of 1987. As per the record, as per my school certificate, as per the PAN card, as per the reference, as per reference also 27 years in the year 2011. So
Your school certificate is not proved. So leaving aside your school certificate, the other documents, you are saying that your PAN card, your voter ID card, right?
voter ID. Voter ID, my lord. My lord, no question put to
No,
the
there was
to
no cross.
Fatima Bibi, my father, mother, and myself.
There was
No,
no
that
cross.
you are not the son of Fatima Bibi and Shunar
We
Ali.
understood. There was no cross to that record.
Some discrepancy may be there.
Hmm.
As per the Muslim Mondal another,
Hmm.
and page number there is para 121. Tribunal has rendered his opinion rejecting the evidence adduced by the appellant.
Hmm.
On the ground that appellant could not prove that her family member
Hmm.
have been living in Assam prior to 25th 2071. The tribunal also held that in the exhibit BC, that is the electoral roll of 66 and 70, the name of Imtaz Ali, son of Abdul Ali, appears, but in NRC of 1951, exhibit G, the father's name was Imtaz Ali, is shown as Abdul Sheikh. Earlier it was Abdul Ali, here Abdul Sheikh. The tribunal also found the discrepancy in the age of Imtaz Ali. Age, as mentioned, exhibit B and G. Tribunal, however, overlooked the evidence of the appellant that he was born and brought up at village Patikusi under Borgata police station, and she was a student of Medhirtari High School. The appellant has also proved exhibit A, the school certificate issued by headmaster, which was not disbelieved by the tribunal, but here disbelieved to some discrepancy. Such positive statement of the appellant has not been challenged by the state during cross-examination. Not challenged during cross-examination. Nothing put, nothing shook me that you are not citizen, you are not born on that day. Your father is not Ibrahim Ali, your mother is not Fatima Bibi. Nothing put. So no irrefutable evidence. Whatever required under Section 9 of Foreign Affairs 1946, I have discharged my burden.
You are.
But after
You are judgment of Muslim Mandal. This is
another case also here,
Mr. Counsel. This reported in 2011 CGLT. Which judgment you have just read?
Lordship 2013
Ah,
1 GLT 809. Case number
121.
121. And another 122 to 2.
What is the next citation?
Those state has cross-examined.
Which page?
Which
122.
was 74.
Same judgment.
Same case. Though state has cross-examined the witnesses, there was absolutely no cross-examination relating to the claim of the appellant that Sahib Ali is her father, whose name appeared in electoral rolls of 1966 and 1970 in respect of Jonia LSE. In evidence adduced by the state, that is deposition of SI, but here is no evidence adduced by the government state. Exhibit 1, the report, no rebuttal evidence. Here also no rebuttal evidence also could be led by the state to demonstrate that Sahib Ali is not father of the appellant, whose name appeared in the aforesaid electoral roll. So, this judgment is the appropriate judgment. This may be relied.
Can you
By
give us
this
the
honorable
paragraph number? Paragraph number.
Paragraph 122.1. And another Sarbanand Sonwal 2.
122.2.
1.
The other page 74.
75. 74 to 75.
Which are the paragraph? Page 74 that you have said about. Which paragraph? Page 74.
122.1.
Okay.
My lord, another judgment, Sarvananda Sonwal 2, 2007, Supreme Court cases 174. Para 55. There cannot, however, be any doubt whatsoever that adequate care should be taken to see that no genuine citizen of India is thrown out of the country. A person who claims himself to be a citizen of India in terms of the Constitution of India or Citizenship Act is entitled to all safeguard, both substantive and procedural, provided for therein to show that he is a citizen. So it is a most precious right, citizenship right. So he should be, Your Honor, Your Lordship may scrutinize the, verify the matters, whether he is a citizen or not. In another of the same judgment, 62, para 62, Sarvananda Sonwal 2, there is good and sound reason for placing, that is date of birth so and so, a good and sound reason for placing burden of proof upon person concerned who asserts to be a citizen of a particular country. In order to establish one citizenship, normally he may be required to give evidence his date of birth, place of birth, and name of parents, their place of birth and citizenship. Sometimes the date of birth of the grandparents may be relevant, like under section so and so of Citizenship Act. All facts would be necessary be within the personal knowledge of the person concerned and not the authorities of the state. Thereafter, after he has been given evidence on this point, state authorities can verify. This is very much essential. After he has given evidence on this point, the state authorities can verify the fact and can then lead evidence in rebuttal if necessary, but no evidence led by the state to give irrefutable evidence because our evidence is irrefutable. So under this facts and circumstances, as the law point cited, Your Lordship may be kindly be pleased to declare the petitioner a citizen of India by birth.
Come to paragraph 62 of the Sarvananda Sonwal 2. Do you have a copy of the judgment?
Yes, doctor.
Kindly read para 62.
It was stated Sonwal case 1 FCC 695 96 para 26. There is a good
Mr. Just remove the Kohara. Now
Yes,
you
Lord.
submit.
para 62 saying about para 26 of Sarvananda Sonwal 1 case, Lordship.
Kindly read.
There is a good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to be give evidence of his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary. If the state authorities dispute the claim of the citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. This is in accordance with the underlying policy of Section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Lordship. The court,
So now tell us about the impugned opinion. You have heard the counsel for the
Lordship.
petitioner who clearly stated the alleged father and mother of the petitioner Ibrahim Ali and Fatima Bibi deposed before the tribe
Lordship.
that the proceeding is their son and that the father Ibrahim Ali categorically stated that the proceeding was born to Fatima Bibi, who is his wife.
Lordship.
What do you have to say? Please take your
Lord-
seat.
Lordship, regarding that, Lordship, I want to rely on a decision of this honorable court in WPC 562/2016, Lordship.
WPC
562/2016.
Hmm.
Vijaydas versus Union of India.
WPC
562/2016.
uh,
Lordship, para 17.
just a-
Para 17, Lordship.
yes, please read.
It is tried that mere filing of written statement and oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceeding by adducing documentary evidence which are admissible and relevant. The two documents filed by the petitioner were not proved in any manner whatsoever, and therefore the assertion of the petitioner that he, being the son of Bipul Das, who was a citizen of India, was therefore a citizen of India, was not proved, Lordship. Again, Lordship, another decision of this honorable court, Lordship.
Just a minute. Yes, this is the other decision.
Lordship, WPC 1900/2019. 1900/2019.
WPC
1900/2019. Page 4, second para.
Decided when?
Lordship, decided on Lordship 18 to 2020, Lord. 18 to 2020. Noor Begum. Noor Begum versus Union of India. 1900/2019. Case for second para Lordship. Statement of DW2.
Para?
Case for second para Lordship. This statement of DW2, Lord. Statement of DW2. Jahrun Begum. The statement of DW2, that is Jahrun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in the absence of any documents showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony of DW2 alone sans any documentary support cannot be treated as sufficient to prove linkage or help the cause of the petitioner. Surprisingly, the petitioner failed to produce a single voter list in her name even until the age of 50 years. We would reiterate that the proceeding under Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship.
Okay.
Again, Lordship, another case, Lordship, 4020/2017. 4020/2017. Asia Khatun versus Union of India. Your Lordship, phase 3.
Just a minute. Yes.
In phase 3, second para Lordship, statement of DW2. Lordship.
Kindly read.
The statement of DW2, that is Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in the absence of any documents showing his relationship to the petitioner. In this, we would observe that the proceeding under Foreigners Act 1946 and the Foreigners Tribunals Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. The evidence of DW2 thus falls short of being considered as cogent, reliable, and admissible evidence so much so to establish the linkage of the petitioner to him.
Anything?
And Lordship, regarding rebuttal evidence, Lordship, I want to place one judgment of this honorable court, Lordship, State versus Ohab Ali. Lordship.
Kindly give the number.
WPC number 2641/2017. State of Assam versus Ohab Ali. WPC 2641/2017. Here, para 16 Lordship. Para 16 Lordship.
Just a minute.
Para 16. On the other hand.
Para 16,
Yes, Lordship.
16.
Yes, Lordship.
Yeah.
On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that they did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by full bench of this court in State of Assam versus Muslim Mondal reported in 2013 1 GLT 809. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the fact in issue. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevancy, it cannot be said that the proceedee had discharged his burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance.
Good. Now, reading with this and para 62 of the Sarvandra Sonwal 2, just tell us. Reading this para 16 and Sarvananda Sonwal, para 62, which is the para 26 in the original Sarvananda Sonwal, the first Sarvananda. Tell us.
Lordship,
In the Sarvandra Sonwal 2, you have just read para 62. What was the observation made in the para 26 of the Sarvandra?
There is a good and sound reason for placing the burden of proof upon the person concerned and who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under Section 61A(d) of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned, and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can lay evidence in rebuttal if necessary, Lordship.
Now just tell us.
No.
That's why I have asked you to read.
So, Lordship, as per this section, this paragraph, Lordship,
26 of the original one.
yes, Lordship, 26 of the original, Lordship. That Lordship, he cannot able to prove that Lordship, he is the father.
The Honorable Apex Court in the Surrenders Annual in para 26 has clearly laid down 4 things.
Lord.
First of all, date of birth
Yes, Lord.
of the proceeding,
In that,
his place of birth,
Lordship.
name of his parents,
Yes,
and their place of birth and citizens.
Lordship.
These 4 parts. And then there's another point it's given provided here is that sometimes the place of birth of his grandparents may also be relevant,
Yes, Lord.
like under section 6A1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge
Yes,
of the
Lord.
person,
Yes, Lord.
not of the authority.
Hmm.
Thereafter, once he places all these,
Lord.
it can be rebutted by the authority.
Yes, Lord.
Here, the petitioner claimed that
Hmm.
Ibrahim Ali
Hmm.
is his father
Hmm.
and Fatima Bibi is his mother.
Yes.
But nowhere he mentioned in his written statement his place of birth.
Yes, Lord.
You read the written statement,
Yes, Doctor.
and neither the evidence of Ibrahim Ali or Fatima Bibi, the
Lord.
place where he has and on when he has born, because his certificate, school certificate was not proved
Lord.
by producing the original register.
Yes.
So date of birth, only thing is the Gaonbura certificate is a place of residence.
Lord.
It is not the place of birth.
Yes, Lord.
And also specifically mentioned in his cross evidence of the Gaonbura that since when he was a resident of that particular place, it's not there. It is very clear in his evidence of the Gaonbura. Right? So you tell us.
If Lordship, his place of birth is not there, Lordship, he is not able to
He
prove
has
his
only stated that Ibrahim Ali is his
place of
father
residence.
and Fatima Bibi is his mother.
Yes.
Ibrahim Ali of village of district Dharam and Fatima Bibi of district Nalbari.
Lordship.
Ibrahim Ali has deposed that the proceeding is his son. Fatima Bibi has also deposed that Ibrahim Ali is her son. So it's not enough.
Yes, Lordship.
It's not enough to prove the citizenship.
No, no.
Why?
Because Lordship, here Lordship will kindly see here their base document is the school certificate, Lordship. School certificate, Lordship. How they
Your case is that the proceeding case you've been tried to be established to be proved by the Ibrahim Ali and Fatima Bibi by their evidence.
Lordship,
These are oral evidence.
oral evidence.
And there is no such documentary evidence to link that statement, right?
Yes.
So, yes, then please proceed. Wanted to say something more.
Lordship, regarding Lordship,
Bottle list of 1985 students.
school certificate,
Hmm.
cross part Lordship, page 33.
Hmm.
Last part, on the request of the villagers and Fatima Bibi, I issued the Exhibit 14, that is school certificate. Lord.
Then read for it.
And though Ibrahim Ali was residing occasionally at Dolgao, and instead of issued the certificate, and insisted to issue the certificate giving the address of Dolgao, Lordship.
But not given.
I have not brought any admission register and any other records of this school today before this tribunal. It is not a fact that Exhibit 14 was issued falsely. I consulted the Gaubura at the time of issuing the certificate. Lordship, that means there is no record regarding this proceeding, Lordship. Also, date of birth is not there in this.
It is there. As per the school record.
But that is not proof, Lordship.
Say that.
My lord, I
We'll come
claim.
back to, we'll come back. Mr. Payang, you want to place anything in addition to Mr. Sharma, what he has said?
Just I want to rely, my lord, your lordship has, as your lordship has put it this question, my lord. My lord, the contention was that, my lord, the as per para 26, the date of birth, place of birth, my lord, father's residence and father's address, and citizenship of our father. This has to be proved. We don't want more than that, my lord. This must only. If it is proved, once proved, with my lord bringing cogent and reliable evidence, which is admissible, my lord, then there may be rebuttal, my lord. Then we may go for rebuttal, my lord. Unless until it is proved by bringing cogent and reliable, my lord, admissible evidence, it is not necessary for us to go for rebuttal, my lord. Because the my lord, para 26 of the Sabananda Sunwala has clearly said, if necessary, it is not mandatory, my lord. If necessary, then only this that may go for rebuttal. So it is not that mandatory that we must go for rebuttal. My lord. So it is clear, my lord. So first of all, it is we have to see whether the petitioner could prove his date of birth, my lord. Date of birth he could not prove. Place of birth he could not prove by bringing any evidence, my lord, any reliable and cogent. So unless until date of birth and place of birth is proved, my lord, so it is not necessary for us to go for rebuttal. Because the school certificate, my lord, which is relied, that has gone because the headmaster could not say, my lord, the headmaster has himself said, my lord, he has issued that certificate on the on insistence of the, my lord, petition. He has no record. So it is not, it cannot be said that it is proved. Second thing, my lord, electoral photo identity and voter. So rebuttal part is not necessary at all. My lord, one more thing, as my learned friend has argued, my lord, the point of section 3A, by date of by birth, he should get the citizenship of India. To get the, my lord, citizenship under section 3A, my lord, he should go for strict proof of his date of birth and place of birth in India, unless it's until first point, my lord, because he is claiming that by birth I should get a citizenship. His date of birth itself is not proof, and his place of birth itself is not proof. Unless until it is proof, my lord, he cannot see, he cannot claim for my lord, citizenship under 3A. Secondly, my lord, there is these proceedings are under special provision of 6A, my lord, because 6A is especially given to the persons who has come from, my lord, erstwhile East Pakistan, my lord. So once a special provision is given to them, my lord, they cannot claim for, my lord, general provision of law. So special provision is given to them. They have to claim their, my lord, right under the special provision of law, and that has to be followed. 6A is to be followed. Here 3A will not come, because 3A is a general provision for all, my lord, and special provision is 6A. Because 6A, my lord, we have given some relaxation to them. If we go for 3A, we'll have to see whether his parents and grandparents were there in prior to 1948. Because 6A is a different provision, my lord. 6A, 3A is a different provision. And if we come to 6A, it will 66, my lord. It will come 66 after 6A. So these relaxation are given in 6A. If he is getting the special provision under 6A, he cannot claim general provision, my lord, the relaxed general provision under 3A, my lord. So that is not, that cannot be. And regarding PAN cards, voter ID, my lord, it is, we have judgment of this honorable courts, my lord, that this cannot be accepted as a piece of documentary evidence to establish his citizenship. My lord, this is WPC number 3547 of 2016.
Kindly repeat.
3547
Hmm.
of 2016, my lord.
Hmm.
Babul Islam versus Union of India.
Just a yes.
My lord, here your lordship may kindly see. My lord, your lordship will find it is starting from para, my lord, 20 onwards. Para 20.
Para.
Para 20, 20.
Huh.
This documents
Mr.
were
Payne,
not.
just a minute. Yes.
My lord, your lordship may kindly para 20, my lord.
Hmm.
This, in fact, my lord, this judgment is relied on the earlier judgment of this honorable court, that is Rubia Khatun. I will press that, my lord. Before that, my lord, this is para 20. These documents were not proved accordance with law. That apart, we have grave doubt about the genuineness of the income tax PAN card having regard to the provisions contained in Section 139A of the Income Tax Act 1961, read with Rule 114 of the Income Tax Rule 1962. While Section 159A provides for the categories of persons who are required to obtain PAN card, Rule 114 and Form 49A lay down the procedure for obtaining PAN card. Without complying with the legal requirement as per the aforesaid provision, sudden filing of the PAN card cannot be accepted and relied upon. In fact, my lord, this is, and prior to that, my lord, this as
In
this honorable
Mr. Pang, in some of the cases, we have seen that the court as well as the tribunal did not accept the PAN card because the proceeding failed to place anything before the tribunal.
Yes.
Or could not place anything during the hearing of the matter before the court.
Yes.
That the procedure was paying income tax.
Yes, that's your lordship will find it para next, my lord, the Musammat Rabia Khatun. This has been relied on here. Your lordship may kindly see that original one, my lord. That is WPC, my lord, 4986 2016. It is 4986 of 2016, my lord. Rabia Khatun. In fact, it is my lord, placed in this judgment itself from para 17, relied in para 17, from para 17 onwards.
Mr. Pang, just a minute. Yes, please carry on.
My lord, in fact, my lord, that is WPC 4986 2016. That is, my lord, in fact, it is relied on in this judgment also. Para from and quoted from para 17 onwards. That is relevant, my lord.
4986 2016.
Yes, madam.
Rabia Khatun.
Rabia Khatun, madam. It is detailed discussion is there. Para 17 onwards.
Yes. Para
Para 17, madam. 17. Petitioner introduced Exhibit 5, a PAN card of the Income Tax Department, wherein Rabia Khatun was shown as related to Kudus Ali, and her date of birth was mentioned as 10/9/1974. At 17, Tribunal took the view that PAN card could not be treated as a trustworthy documents. We concur with the view of the Tribunal for more than one reason. Firstly, petitioner is not an income tax payee. There is no record of filing of return income tax by the petitioner at any point of time. Therefore, petitioner appears to be from an agricultural background. Agricultural income is exempt from the purview of Income Tax Act 1961. Therefore, obtaining PAN card by the petitioner appears to be quite unusual. Secondly, the PAN card was not proved by tendering evidence of the Income Tax Authority. Had a responsible officer of the Income Tax Department deposed before the tribunal, it would have been clear as to whether the petitioner had indeed made any application for obtaining PAN card and the particulars of such application. In the absence of thereof, no credence can be given to the PAN card. Thirdly, the PAN card categorically mentioned the date of birth of mentioned the date 10/9/1974, which may be presumed by the date of birth of the card holder. If the date of birth was known to the petitioner, certainly the same should have been mentioned in the written statement as well as evidence in safe filed by the affidavit. But that was not done. Therefore, Exhibit 5 cannot be said to be a valid piece of evidence to establish that Quddus Ali was citizen of India, and that Rabia Khatun was the daughter of Quddus Ali, and thereby she was a citizen of India. So, net result of this majority failed to discharge her burden under Section 9 of the Foreigners Act to prove that there was no foreigner, she was not a foreigner but citizen. But one thing, my lord, this is clear. Only one thing from the record I want to show. WS she has not stated. My lord. He has not stated regarding his date of birth, my lord. From the pen card, my lord, your lordship will find as per the pen card, his date of birth is sometime 1 to 1985. So, as per the pen code, it is my lord, his date of birth is 1 to 1985. So that is not a pleaded case, my lord. And but surprisingly, in my lord, school certificate, he himself contradicted the same, my lord. In the school certificate, he said his date of birth is 1/1/1987. One 1987. School certificate is probably not annexed in this matter.
It's there,
Petition.
it's there. Certificate is there. A part of evidence.
Yes, it's part of evidence. It's in the record. Record also, my lord, the school
It
certificate.
is there in the record.
Yes, it is there in the record.
71 order judgment reflected.
So, both these documents cannot be relied on for this reason itself, my lord. Because in one case, he said his date of birth is 1 to 1985. In another place, he said 1/1/87. So, either of these documents cannot be accepted as admissible because of my lord's sole reason itself.
What about the voter card?
Voter ID, my lord, in fact, my lord, voter ID, your lordship may kindly see in the earlier judgment itself. It was there in the, my lord, the earlier judgment. Just I have relied, my lord. 3547. 3547, yes. Abul, my lord, para,
Muhammad Babul Islam.
Babul Islam. Para 20.1, my lord. 20.2, my lord. My lord, para 20.2, my lord. In so far as Exhibit 7, that is electoral photo identity card, is concerned, besides not being proved, it is a post-25 to 1971 document. Besides merely producing such identity card in absence of supporting evidence would not be a proof of citizenship. So para 20.2, my lord. Next, my lord, another case, my lord. Another case, your lordship may kindly see 7426 of 2019.
Seven 426.
Of 2019, my lord.
Hmm.
Munindra Biswas. Para 5, my lord. Very good.
Yeah.
Exhibit 2, my lord, it is photo identity card. Is the photo identity card, electoral photo identity card.
Hmm.
So the tribunal has held that exhibit 3 and 4 in a manner required. My lord, this is, my lord, your lordship may kindly say just below the, my lord, the exhibit number 5, third para, my lord. Regarding electoral photo identity card, court has relied on, my lord. Court in case number Babul versus State of Assam has held that electoral photo identity card is not a proof of citizenship. This is, my lord, relied.
Then
Here it
Babul
is
Islam.
relied. Yes, Babul Islam is relied on. There are numbers of judgments, my lord, where it is clearly said that this cannot be used as a piece of evidence for proving citizenship.
Yes. Lord, just, Mr. Ali, you would like to supplement something?
My friend already submitted it because he has relied on the electoral photo identity card. That has been made clear by this division and other coordinators also that electoral photo identity card is not a proof of citizenship. And moreover, your lordship, if we will observe the electoral photo identity card, the back side down below it is clearly written that merely
It is
holding
not a
this,
case of
it
citizenship.
is an electoral roll where they have to prove their citizenship by recording their name. Your lordship.
What do you have to say that his father, proposed alleged father Ibrahim Ali and mother Fatima Bibi has deposed?
Yes, that's it. So by this circumstantial evidence and other corroborative evidence, you will have to establish his fact, your lordship. Not by merely producing the electoral photo identity card that is a proof of his citizenship.
Yes, Lordship.
Was regarding the place of grandfathers, place of birth, these were not discredited in cross-examination. The prosecution ought to have cross-examined in this regard. If nothing disclosed in the written statement or evidence, that might have crossed regarding a place of birth of his parents and grandparents. And a place already been stated, Kasimpur and Boruajar Dorong, that has been stated. And according to PAN card, father submitted PAN card and the mother also submitted PAN card. That the date of birth shows whatever it may be. And I am claiming that I am citizen of India by birth because the reference also shows I am 27 years old in the year 2011. And either PAN card or certificate, voter ID or school certificate shows that I am, my date of birth is prior to 1st July 1987. But who is my father? If Fatima Bibi and in the reference also my father's name is written Ibrahim Ali. If he is not, then OPW3, DW3 adduce evidence that I am the father of Positi and he is the eldest son among the other children. but nothing cross, no discredit them. So it is ultimately, it is proved. Burden, I have already discharged my burden. After my discharging burden, state ought to have verified the matters and led evidence to review the evidence, whatever on the record, whatever stated. But no evidence regarding that. And if they are not my father and mother, there might be some father and mother that might be verified by the state. If they are not foreigner, then I can claim. If they are not foreigner, if they are not immune to any case, enemy, he is not related to any enemy of foreign country, then I can claim that I am citizen of India by birth. It is.
But what do you have to say with regard to the law laid down by a coordinated bench of this court earlier, that by mayor submitting that he is the father or mayor would not be enough. There has to be some link document.
Link documents, lordships, some link documents already been given. My voter list also given. Voter list also reflects that my father is Ibrahim Ali. Then my father also submitted a voter list of 1985. Here his grandfather's name is there. Grandfather's voter list of 1965 is given. That is linkage of my father. And I have given Gaubura certificate. I have submitted voter ID. I have submitted PAN card. That shows my father is Ibrahim Ali. This voter ID, that PAN card is not your father. It is not your father. But nothing cross in this regard.
Okay.
And no verification. And earlier occasion, this court also verify. Then to the SP Dorong and SP Nalbari, whether Shunahar Ali is the father of Shangsher Ali, and whether Shangsher Ali has any son in Kasimpur in the district of Nalbari.
That may be a call for, but we have nothing to do with that. We are in certiorari proceeding, right?
This court, same court,
Doesn't matter.
call for the records, the
Doesn't
verification
matter.
report, inquiry report.
Then why the reference was required?
Huh?
Why the reference was made?
And in the reference, losses,
Okay.
reference should be satisfied to some extent at first, though as per provision of section 9, the proceeding might have proved the citizenship, but at least prima facie case to be established by the state to the satisfaction of the tribunal. Reference to the reference. Here also, Bipul Boro, the witness is Bipul Boro as per statement, but Bipul Boro already given evidence in favor of the proceeding and issued two certificates. But here, Bipul Boro is the witness, the complainant. And Shangsher Ali, name of person Shunahar Ali, father, form 2, annexer 2, father's name Ibrahim Ali, marital status married, a particular of spouse that is rightly written, Icon Bibi, Akiban Bibi, address of county that might have been disclosed, that might have been recorded, address of the county of origin not disclosed. Then how he is a foreigner? Village, police station, district, county, not written here.
Okay. Heard Mr. Esteban, learned counsel for the petition. And MSLDP learned CGC for the respondent number 1. Also heard Mr. Depai, along with Mr. G. Sharma, learned standing counsels for the home report for the respondent numbers 2 and 3, and Mr. P. Sharma, government reporter, Assam, for the respondent. Please stop. Right. 60. Yes, one to one. Yes, Mr. Bhargava.
May I please, Your Lordships? Here is the petitioner. Name is Lal Banu. Grandfather's name is Sikandar Ali. Grandmother's name is Basatunnesa. Father's name is Dulal Sheikh. Mother is Majala Khan. The reference made in this case, Lordship, that is page 69, on the basis of inquiry report. This reference was forwarded before the tribunal, page 69. My name recorded and my husband's name. I married woman. After marriage, Lordships, due to it is a deputed case against my name, D was marked, and as such, this reference a verification was conducted. But verification, Lordship, find totally blank because there is no inquiry at all. No inquiry. On the basis of D, Lordship, this the form was forwarded before the tribunal. Tribunal issued notice, that is page 38. Page 30 is the notice, Lordship. Vernacular is page 39. On receipt of notice, I entered appearance, submitted a written statement, that is page 40. I have details stated regarding my place of birth, my family tree, father's name, their name, and entered in the voter list also. And in the paragraph 2 also, Lordship will find that respondent Lalban was born and brought up village Romari under Bagwan Police District, Alpara. Respondent's parents, grandparents also bona fide citizens of India by birth. The name of respondent's grandfather, Sikandari, was enrolled in the voter list 6670 at village Romari under Bagwan PSS district, Alpara. Then the name of the grandfather enrolled the voter 1977 by number so in the village.
Mr. Payam, we'll admit this. Record is here. We'll fix the matter for hearing. Third, Mr. Rafe Borvier, learned counsel appearing for the petitioner.
Not to be deported, arrested.
RMS LDV, learned CCC for the respondent number 1, as well as the standing counsel, state coordinator RC Assam, respondent number 5. Also heard Mr. J. Payang, standing counsel, Home Department, the state, for respondent number 2, 6, and 7, as well as Mr. A.I. Ali, standing counsel, Election Commission of India, for the respondent number 3. I've also heard Mr. P. Sharma, Government Advocate Assam, for the respondent number 4. Peruse the office note. The relevant records of the concerned tribunal received by the registry. Matter be admitted for hearing. Registry shall list the matter for hearing in its course.
Oblige.
Item 3.
May I please your lordship, this matter pertains to allotment of the year in the All India service. May I just inform your lordship, my senior on the other side, he has expressed some difficulty today, Mr. M.K. Chaudhary. If it can be day after tomorrow, lordship,
Item 3.
sweet lordship. Otherwise, it pertains to the year of allotment in the All India service.
Year of allotment
Year
of seniority
no,
Regard-
IS.
of the IS. Okay. Just a minute. On the prayer of the council for the project list on paper.
Oblige. Oblige.
Four.
My lord, in this case, my lord, some accommodation may be given to me, my lord. Some accommodation may be given to me, my
What
lord.
kind of accommodation?
My lord, my brother was, my lord, suffering from cancer. He has undergone operation yesterday. No, so I was for the day, my lord, I could not prepare the case. So, my lord, lordship may kindly fix the matter on 9. I have already, my lord, informed.
Tenth,
10th, my lord. Oblige.
not 10, 12,
12, my lord, I'll go out of station. 11, 12, I'll go out of station.
10. On the prayer of the council for the Yes, Mr. Nath.
My lord, in this case, my lord, possible find the impugn order page 22. By this order, my lord, the petitioner has been declared foreigners on the ground that only, my lord, he could not produce any voter list of his father. Page 23, your lordship will find the documents exhibited.
Hmm.
He exhibited as many as 9 documents.
Hmm.
Exhibit 1 is the sale deed of 1952. 2 is the photocopy of land revenue receipt, 1956. Exhibit 3 is the affidavit. 4 is the photostat copy of certified voter list of 1997 of the petitioner. 5 is the photocopy of the certified copy of 2014 of the voter list of the petitioner. 6 is the photocopy of the electricity bill 2013. 7 is the photocopy of the first passbook. 8 is the photocopy of the family card of, it's called job card. 9 is the certificate issued by the government. So, my lord, out of these documents, the tribunal held that the petitioner failed to prove his citizenship and linkage with his father. But later on, my lord, he could obtain this voter list of his father. You will find page 14, 1965 voter list. That, although that was not produced before the tribunal, but it's found that the name of his father is there. So, if that could be proved, then here his father is page 14, Joydev, and grandfather name is Sharat Chandra, age 35, year 1965. So, and also one school certificate as a linkage, page 25, you will find, that was also not proved, my lord. Page 25, last page. Here also, my lord, Dhananjay Chandra Biswas, Joydev Chandra Biswas. But this is also disputed, my lord. His title was earlier Biswas. And later on, he has changed his title from Biswas to Sarkar. And on this ground also, my lord, tribunal disbelieved his linkage with father. So, but other documents, my lord, sale deed of 1952, although that
Mr.
was
Nath,
proved.
just tell us one thing.
Lord,
By filing an affidavit, can you show that Biswas and Sarkar is the same in one person? Have you proved
there is
the person, the headmaster of the school who issued that certificate?
no, my lord, that was not proved. That was not proved also, my lord, that certificate was also not exhibited, my lord.
Okay.
It was not exhibited. And only the Gaubuda certificate was exhibited, but that was not proved, my lord. Gaubuda was not examined, so it has not been considered.
We have the records with us.
Lordship.
Now, what we have noticed, you have annexed, you have exhibited as per this opinion, sale deed and revenue paying receipt. Then the voter list of 1997, right?
Yes, ma'am. 1997 was exhibited.
That's your exhibit 4. Now, exhibit 4 voter list is at page
Page, Lordship will find page 16. Page 16.
You are Dhananjay Sarkar, right?
Dhananjay Sarkar, madam.
Come to page 17.
Yes, madam.
It's only a photocopy, it's not a certified copy. As you know, to be a certified copy, in the footing there has to be.
This is the my lord. Yes, my lord. Signature is there, my lord.
Signature on to.
Yes, my lord. That is also round seal is there, my lord.
That will not be enough. It has to be a certified to be a true copy, right? Where
That
is
does
that
not-
by the authority concerned?
That has not been mentioned, my lord. That may be wrong done by the authority, my lord, but
that cannot be, you know Evidence Act very well. Unless that
but
thing is there.
date of application is there, date of
Everything is
delivery
there.
is there, my lord.
Read section 76 of the Evidence Act. Can
That
you go
is-
beyond that? Do you
Yes,
have any
my-
Evidence Act?
Yes, my lord, that is
So,
there, my lord, that is there.
How can
That
we
is
accept
admitted.
it as a,
There is no dispute on this ground, my lord. But since this is the wrong done by the authority, my lord.
no, not. Don't say at this stage. If it was found wrong and it should not have been accepted, you should have, that's it.
But
That's
there
a
is no
voter
any
list of which year? That's a voter list of 1997.
97, my lord.
Now come to the voter list of 2014.
Yes, my lord. You will find page, particular page 20.
Good. There you see. On the left side at page 20 down below. Oityo Pramanito Nokol on the left of page 20.
Plus, yes.
So copy of the certified copy it can be accepted, but not your page 19, page 18. Sorry, page 17, the voter list of 1997. By mayor filing an affidavit saying that the Dhananjay Sarkar, that the Joydev Biswas and the Joydev Sarkar is the same in one person, will you be able to prove it? That also an affidavit by you, because it is not by Joydev Biswas or Joydev Sarkar.
Jaydev Sarkar, his father was not alive at that time, my lord.
Exactly. Now, how come, on what basis the affidavit has to be taken as the consideration as a piece of evidence to that extent? Hmm? Yes. Anything else?
In my, in my WS mallet, I have stated that the name of the father of the petitioner, uh, although was Jaydev Biswas, but thereafter he has changed his title from Biswas to Sarkar. So, in this respect, my lord, petitioner has given the explanation. An affidavit regarding affidavit, my lord, today, my lord, I'll show one decision on this point. And today I'm not having, although affidavit on oath is also my lord, a piece of evidence which could be considered, my lord, if it is corroborated with other evidences. And in the school certificate also it is shown that his earlier title was Sarkar Biswas, and Dhananjay Biswas, son of Jaydev Chandra Biswas. So, regarding his title, there is some document of school certificate, which was not, could not be, my lord, placed. So, if the petitioner could have placed this, my lord, he could have succeeded. So, Lordship may remand the matter so that he can
For what? For
prove
what?
it, my lord.
For what we remand?
For
what
proving
reason?
this school certificate, man. And also voter list of 1965. That was not exhibited.
First
my
of
lord.
all, what's your link document?
Link document, my lord, school certificate.
School certificate?
Page 25, my lord, school certificate. Which could not be proved, my lord. Which shows that he studied in the year 1977 and studied up to class 5 and promoted to class 6.
Where is your written statement?
Written statement, my lord.
Have you annexed?
No, my lord, that is
You
not
have
annexed,
not
my lord.
annexed.
That was
Okay, let us see the record. What you have stated. You have a copy of the written statement?
yes, my lord, I am having.
You have.
Yes.
Kindly read, because we have a copy of the handwritten copy of your affidavit, written statement.
Yes, my lord, that is also handwritten, my lord. From para 4, my lord, is relevant. That the opposite party was born in Bakulguri village under Betana Moja under Rangia police station in the district of Kamrup, Assam, and he shifted his residence from aforesaid address to the present address where he has been residing with his family members permanently. That the SP border Nalbari falsely forwarded the case to the Foreigners Tribunal number 4 Nalbari Gagrapar for opinion as to whether the opposite party entered into Assam in between the period from 1st January 1966 and 24 March of 1971 or on or after 25th March 1971 illegally. That the forwarding report is itself vague and concocted. That the boundary duty and obligation of the police was not done. The police never visited the house of the opposite party so as to submit enough documentary evidence to establish that the opposite party is not foreigner. That the border police shifted to burden upon the opposite party and does not give any opportunity to produce any documentary evidence to discharge such burden. That the opposite party furnishes the relevant and documents in support of his Indian citizenship bona fide before this tribunal. That the reference has been initiated and notice has been issued to the opposite party to submit written statement and objection and relevant documents and asked the OP to attend the tribunal personally. That as the burden of proof is on the opposite party to prove that the OP is not a foreigner. But the state is to first adduce evidence confine the grounds on which the reference is pressed before the OP is to discharge the burden to prove that he is not a foreigner. That the OP's father name is late Joydev Biswas, who was an Indian citizen by birth. He was living at village Bakulguri under Rangia PS in the district of Kamrup, and the opposite party has changed his surname from Biswas to Sarkar from the very beginning of his childhood. Hence, in all of his documents, his name is recorded as Dhananjay Sarkar, where his father's name also recorded as Joydev Sarkar. Instead of Joydev Biswas, that Joydev Biswas and Joydev Sarkar is the same and one person with same identity, that is of his father. That the OP has submitted the following documents and document in support of his Indian citizenship by birth. That the OP's father, late Joydev Biswas, son of late Sharat Chandra Biswas, executed a registered deed, sale deed by deed number so and so.
Lease.
Yes, my lordship, that is lease deed by deed number so and so of 1952 of a plot of land situated at village Bakulguri under Betana Moja, PS Rangia in the district of Kamrup, Assam. Photostat copy of the said lease deed is enclosed as Exhibit 1. That the father of the OP paid land revenue from annual patta number 2 of village Bakulguri under Betana Moja on 3756 for the year 1950-53. Photostat copy of the said land revenue is enclosed as Exhibit 2. That OP's son Sri Parimal Sarkar Parimal Sarkar swore an affidavit regarding the name of his father, stating that Joydev Biswas and Joydev Sarkar are same and one person, same identity, and which is his grandfather. Photostat copy of the said affidavit is enclosed as Exhibit 3. That the OP's name appears in the voter list of 1997 as Dhananjay Sarkar, son of Joydev. But CL number 503, house number 149, part number 2 for village Neharbari under 59 Nalbari LSC.
Okay, we'll come back at 2, Mr. Nath.
Plus,
Okay,
plus.
the remaining portion. In the meanwhile, if you want to go to the record, go through it.
So WS Malad, it is revealed that Malad, he has explained regarding his change of title. And accordingly, he has submitted on affidavit also, which was not considered. But my lord may submit the alternative, my lord, remedy is that, my lord, under the protection of, because he has stated that due to religious persecution, he has entered into, his father entered in 1951, and also under lordship provision of section 3A of Foreigners Order 1948. After the notification of 2015, these classes has been exempted from certain classes for application of these foreigners. Section 6A of the Foreigners Act. Section 3A, my lord, it is provided that persons belonging to minority communities in Afghanistan, Bangladesh, and Pakistan, namely Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians, who are compelled to seek shelter in India due to religious persecution or fear of religious persecution and entered into India on or before 31st December 2014. It is admitted that, my lord, case was instituted before 2014. Without valid documents, including passport or other travel documents, and who have been exempted under Rule 4 from the provisions of Rule 3, the Passport Entry into India Rules 1950, made under Section 3 of the Passport Entry into India Act 1920. With valid documents, including passport or other travel documents, and other validity of such documents has expired, are hereby granted exemption from the application of the provisions of the Foreigners Act 1946, on of 1946, and the orders made thereunder in respect of their stay in India without such documents or after the expiry of the documents, as the case may be, from the date of publication of this order in the official gazette. So, my lord, under this provision, petitioner may be allowed to seek protection and to file appropriate application for registration.
How is it possible?
Because, my lord, under the also Citizenship Act, Section 6B.
First of all, that was not your case. It's not your pleaded case before the tribunal.
Although
Right.
it is, although,
Now-
my lord,
Now you.
but this is the legal protection, my lord, that can be taken at any stage. Because in so many cases also this court has granted
Say
liberty.
basically, during the inquiry, it was found and suspected to be a foreign national who has entered the territory of India.
Yes, my lord, suspected due to
And
that, my lord, he could not
after-
furnish.
After 1971 illegally, right? So you have to be a foreigner. For that purpose, the reference was made
Yes, my
to
lord.
the tribunal. Tribunal gave you notice. Now your present case in the present pleaded case is that the school certificate was issued by the concerned school headmaster.
Oh,
and
that
then,
was not, my lord, yes.
That was not exhibited,
That was not exhibited.
and so you should be given a chance.
Yes, my lord. That is also
And
one of my case, my lord.
That is, now thing is this. In your written statement, you have clearly stated, first of thing, that para 4 you have already read.
Yes,
Your
my
written
lord.
statement.
Para
You
4 we have,
stated that the opposite party was born in Bokulguri village under Patna Moja, under Rongia police station in the district of Kamrup, Assam.
yes, my lord.
And he shifted his residence. He, the proceeding,
Yes, my lord. From
shifted his residence from aforesaid address
the
to
present
the
address,
present address,
present address.
where he has been residing with his family members permanently,
Yes, my
right? So from The jurisdiction of Rongia police station, you have shifted to the present place, which is under Nalbari.
Nalbari district.
Right. So at para 12 of your written statement,
Lost.
you stated that the opposite party's father's name is late Joydev Biswas, who was an Indian citizen by birth. He was living at village Gokulguri under Rongia police station in the district of Kamrup. And the opposite party has changed his surname from Biswas to Sarkar from the very beginning of his childhood. Hence, in all of his documents, his name is recorded as Dhananjay Sarkar, where his father's name is also recorded as Joydeep Sarkar instead of Joydeep Biswas. That Joydeep Biswas and Joydeep Sarkar is the same and one person with the same identity. That is the opposite party, right? Opposite party's father. Now, if you come to page number 25 of your writ petition, Annexure H, it is a transfer certificate issued by the headmaster of Milon ME School, Nalbari.
Nalbari, my lord.
It was issued on 9th of August 2017, certifying that Sri Dhananjay Chandra Biswas, son of Joydev Chandra Biswas
Biswas, lost.
and Kuloda Devi,
Koloda Devi.
village Nahorbari,
Naharbari.
post office Nahorbari, police station Ghograpar, district Nalbari, left the Milon ME School on 31/12/1977. His date of birth is 28th of January 1965. As per
1965.
school admission register, he was reading in class 5 and had passed the examination for promotion to class 6.
6.
All sums due by him have been paid. Fees up to 31st of December 1977. When in your written statement you have stated that since your childhood, your name has been made Dhananjay Sarkar and your father's name is also known as Joydev Sarkar instead of Joydev Biswas. Why in this certificate your name has been shown as Dhananjay Chandra Biswas, son of Joydev Chandra Biswas? Nowhere you have stated, first of all, that you are Dhananjay Chandra Biswas or your father's name was Joydev Chandra Biswas. Since your childhood, your name is only Dhananjay Chandra Sarkar and Joydev Sarkar. How will you establish this link?
No, my lord, it
You have
is-
never mentioned your mother's name as Kuloda Devi in your written statement.
a mother's name was not
Right.
mentioned, but my lord,
Things are like this.
it
You
is-
cannot now improve your case because there is no mention in your written statement. And further, in your written statement also you have not mentioned that you have read or you have studied in a ME school. There is no mention. There is nothing that the school has provided or given you a school pass certificate or transfer certificate.
Also, Lordship, Lordship, this certificate was issued after the delivery of this order, Lordship.
That we have seen, that we know.
page para 12, it is mentioned that my lord, his father's name is Joydev Biswas.
Maybe
That is mentioned, my lord.
that is mentioned.
Hmm.
But what you have stated is that since your childhood, from very beginning of his childhood, you are Sanjay, you are Dhananjay Sarkar. Then why the school certificate on 9th of August 2017 has been issued? School certificate has to have in the name of school registered. It should be Dhananjay Sarkar. Why it is in the name of Biswas? Will you be able to improve? Because first of all, there is no mention in your written statement
Written statement that
that
is
you have
not in-
studied in any LP school or ME school and the headmaster of the school, there is a registration is in the name of your. You have not stated anywhere. And you cannot go the pleadings. You have to be within the pleading. I think
Yes, sir.
That has
Criminal
been,
bench have already held that beyond pleadings, you cannot go by filing an affidavit, you cannot assume that your father is same person. Were it those judgments, Mr. Sharma?
17.
First of all, the affidavit. Secondly, cannot go beyond the pleading. You have those judgments with you?
Yes, sir.
My lord, pleading, my lord, in this respect, I may submit that, my lord, this is not a proper civil trial.
Doesn't matter. This
So-
law is well fully written. This is the difficulty here. Say, first of
Because
all, we are
it-
sitting.
It is totally, it is law is also, they are totally summary proceeding, my lord. That is also settled law, my lord. Summary
First of
proceeding,
all, we are sitting here only to exercise the power of certiorari. Neither we can accept new documents or whatever is there, right? Fully on the basis of what you have stated in your written statement. We have to see whether the opinion given by the tribunal is right or wrong. Right? Then direction has to be issued. If any document immediately after the opinion has been left out,
but the
you have
plain,
the procedure, you can approach the concerned tribunal itself.
yes, my lord, but
That this
From-
document was available, but at that point of time, we could not place it.
from the plain reading of the order, my lord,
Hmm.
page 24,
Hmm.
although all the exhibited was mentioned,
Hmm.
but no discussion is there, my lord, except opposite party has produced some other documents, electricity bill, so and so, so and so, so and so.
Hmm.
Opposite party has not submitted brutal list of 1965, 66 or 1970, including his father's name.
Hmm.
Though he has produced cell deed of 1952 claiming the name of Jaydev Bishya as his father. In view of the above finding, this tribunal is of the opinion that OBC Janandai
No,
is
see, basically
fairness.
here,
So, my lord,
he has
Regarding-
discussing page number 23 onward.
uh, regarding exhibit 1, 2, 3, 4, 5, and 6, my lord, nothing discussed, and whether those were considered admitted or not, nothing, my lord.
Discuss, that's why in the judgment itself, it is that opinion itself, he has considered. each
Without
and every-
without any proper reasoning, my lord. Only there is no any discussion regarding finding is,
Say, for example, please come to page number 24.
yes, my lord, page 24, my lord.
The second paragraph. Opposite party has produced a sale deed. It's not a sale deed, it's a lease deed.
The list did, my lord, whatever, my
Where the
lord.
name of Joydev Biswas, son of late Sharat Chandra Biswas, is recorded. OP has claimed that this Joydev Biswas is his father. But there is no evidence to establish that this Joydev Biswas is OP's father. Right? Though OP has stated that Joydev Biswas and Joydev Sarkar is the same and one person, there is no cogent evidence to establish it. He has discussed. Exhibit 2 is a land revenue payment receipt dated 3rd of July 1956. From this document, it cannot be said that the said plot of land for which the land revenue was paid is inherited by the opposite party from his father. There is no evidence that the said plot is now in OP's possession. OP has not established his linkage with Joydev Biswas as his father. What other you need? He has discussed.
Regarding, my lord,
Now,
Bhutal list,
OP party has declared is an affidavit dated such and such that late Joydev Biswas, Joydev Kapali and Joydev Sarkar is the same and one person with the same identity, that his father. But there is no supporting evidence to establish this statement. How can you see that it was not discussed? He considered each and every document.
the Bhutal list of, my lord, the petitioner.
Hmm.
Nowhere it is discussed, my lord, regarding Bhutal list of 1997,
Hmm.
nowhere it is mentioned.
Now, just see voter list of 19,
Whether it is admissible or not, that is, my lord, lordship will find.
voter list of which year?
Voter list of, my lord, the petitioner's voter list, my lord, voter list of
1997.
1997
Hmm.
and 2014 also. Page 16 and 17, my lord.
See, he has already initiated that action. Let's see. If you see, he has already decided. OP has not established his linkage with Joydev Biswas as his father.
But in the voter list, the name of Joydev is there. Joydev and his father name, his grandfather name is also same. His grandfather
Joydev.
name and father name
That is the,
are the corroborated, my lord.
that is the reason why in the next paragraph, the tribunal found that Joydev or Joydev Kapali or Joydev Biswas at the same in one person cannot be, there has to be a supporting document, right? Unless there is supporting evidence. The tribunal came to the finding that you failed to give the link to your father Joydev Biswas. The only link that was the lease document and the revenue paying receipt of that land. And that revenue paying receipt, if you see, it was given by Joydev Biswas for sale. And that was the period on 3rd of July 1956 for a year. Because
And
for which year it was paid? It was paid for the year 1952-53.
Yes, my lord. Which proves that, my lord, his father was here. In
Where is the link between?
The link is not link is missing,
Then
but my lord.
the link is missing.
Mm.
How do we expect the opinion to be given by the tribunal should be in your favor? Where is the illegality? Where is the illegality? Even by not discussing your voter list of 1997, that will not help if this is after 1971.
That is after 1971, but
You have to have something before 1971.
that is only on the school certificate. School certificate.
School certificate cannot be. The reason is it was given in the name of Dhananjay Chandra Biswas. And in your written statement, you have clearly stated, since your childhood, your name has been changed from Biswas to Sarkar. How this certificate can be issued on 9th of August 2017?
Maybe at the time of admission, his name is surname was Biswas. My lord. 70, as per this, my lord, he
This is a particular
would have
document.
taken admission in 1971, 65 date of birth, and 77 he was in class 5.
If your date of birth is 1965, why for the first time your name has been included in the voter list of 1997? Why not prior to that?
That may not be obtained, my lord.
Why
He should have.
you was
his
very much
name-
eligible at a relevant point of time.
Yes, my lord. He should have
Then-
included.
All these things are beyond 1971.
At 71, my lord, he should at least would be of 65, 75,
We understood.
10 years.
The first
10
voter
to
list,
12
why
years.
only in 1997? What happened prior to that? What is the reason that your voter name in your voter list was not figured earlier?
That has not been stated clearly in the WF.
In your written statement, you are very silent.
Very silent. I can't-
So
So there is no bar to provide opportunity to take shelter under this provision, my lord, section 3A. So although he has stated that since from the reference, it is mentioned that he has migrated. So if you could prove that he has migrated before 31st December 2014. So under this provision, he is entitled to
what
get
is
the
your
protection.
prayer in this writ petition?
Although there is no specific prayer board, but other relief is there, my lord. Any other relief under the law of the petitioner is provided. Any other relief may be provided, my lord.
So how will you be applicable? Why your case this provision?
Other appropriate order lordship made him fit and proper. It is there, my lord. Because under special circumstances, since special law is there, my lord, amendment, and under the notification of 2019. So this is specifically made. This is the notification, my lord. 2015, December 2015. Lordship is aware of this notification, my lord. And in view of this notification, this amendment has been made, my lord. And also citizenship amendment, section 6A has been amended, 6B is inserted. Although not yet it is even effect, but exemption of certain classes of religions. 3A is there, my lord. According to notification. So, my lord, law can be hesitated at any point of time, although it is not period, it is not fatal to relief.
Yes, Mr. Sharma. But Mr. Nath is saying whether section 6A will be applicable in the case of the petitioner.
My lord, there is not a single statement, lordship. I have found, lordship, that he has migrated from East Pakistan due to religious persecution, lordship.
Yes,
That plea was nowhere taken, lordship. And lordship, already our High Court, lordship, law has been settled by in this respect, lordship. They cannot go beyond pleading, lordship. One case is that, lordship, 2017 4 GLT 346.
2017?
4 GLT 346, lordship. There, para 25. Written statement is basic statement of defense of a proceeding before the Foreigners Tribunal, keeping in mind the mandate of Section 9 of the Foreigners Act 1946. It is incumbent upon the proceeding to disclose at the first instance itself, that is, in his written statement, all the relevant facts, especially within his knowledge, having a material bearing on his claim to citizenship of India. Material facts pleaded in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. It is also tried that a party cannot traverse beyond the pleadings made in the written statement. Para 25, lordship. And so many decisions has been passed by our Honorable High Court, lordship.
Yes, then.
Para 25, lordship.
Yes, that we have said.
Then other decisions are Lordship 2017 GLR 820. Ayesha Khatun versus Union of India. Para 12.
2000.
17 GLR
Hmm.
820. Ayesha Khatun versus Union of India.
AI or IA?
AYESHA. KHATUN
Hmm.
versus Union of India. Here, para 12 Lordship.
Okay. Two 2017 3GLT, right?
Oh, first
GLR.
one is yes, Lordship. GLR 820. Para 12 Lordship. Written statement submitted by a noticee facing a proceeding under the Foreigners Act 1946, read with Foreigners Tribunal Order 1964, is the foundation of his or her defense. Since the citizenship of the noticee is questioned, the noticee should come out with all material facts within his or her exclusive knowledge in terms of Section 9 of the Foreigners Act 1946 and disclose them in the written statement. The averments made in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. Failure to disclose material particulars in the written statement by itself will raise a serious question mark on
Number
this.
820.
Yes, Lordship. GLR 820.
Para 12.
Yes.
Yes.
Para 12. Again, Lordship 2017 5 GLR 670 Zehirul Islam.
20.
2017 5 GLR
Hmm.
670 Zehirul Islam. Here also para 12.
Okay.
In a Lordship.
Para.
Para 12 Lordship. In a proceeding before the Foreigners Tribunal, written statement is the basic statement of defense of a proceeding. When citizenship of a proceeding is questioned, that too by the state, it becomes the burden duty of the proceeding to disclose all the material facts for proving his citizenship, which is specifically within his or her knowledge at the first instance itself. That is in the written statement. This is the requirement of Section 106 of the Evidence Act, read with Section 9 of the Foreigners Act 1946, which has been explained by Supreme Court in Sarbananda Sonowal versus Union of India 2005 5 SCC 655. Failure to disclose such material fact at the first instance, that is in the written statement, may result in the drawing adverse inference against the proceeding.
Para 12, you say?
Yes, Lordship.
Stop to it.
In a proceeding before the foreigners tribunal, written statement is the basic statement of defense of a proceeding.
Fine.
Apart from that, Lordship, regarding self-sworn affidavit, Lordship, I am going to rely on a decision of this honorable court, WPC 2751/2019.
275.
Yes, 2751 of 2019. Para 12, Lordship.
Katarjan Nisa.
Yes, Lordship. Conversion. Para 12.
Yes.
Para 12, the petitioner had sought to clarify the discrepancies found in respect of the names of her projected father by submitting a self-sworn affidavit. It is a settled legal position that an affidavit is not evidence within the meaning of Section 3 of the Evidence Act 1872. Affidavits are not included within the purview of the definition of evidence. It is held in Ayub Khan, Nur Khan Pathan versus State of Maharashtra and others, 2013 4 SCC 465, that the filing of an affidavit of one's own statement in one's own favor cannot be regarded as sufficient evidence for any court or tribunal on the basis of which it can come to a conclusion as regards a particular fact situation. Lordship.
Anything else?
Lordship. Lordship, another is regarding self-sworn affidavit, Lordship. WPC 7643/2017.
4.
7643. Of 2017. Arotibala Mondal. Page 5, Lordship. First para from middle, Lordship. Exhibit 7. In this regard, learned counsel for the petitioner also refers to Exhibit 7, which is an affidavit filed by the petitioner.
Which para you are reading?
Lordship, page 5, Lordship. Page 5, first para, referring to Exhibit 5, Lordship, started. Then, Lordship, Exhibit 7. In this regard, Learned Counsel for the petitioner also refers to Exhibit 7. Lordship. Counsel for the petitioner also refers to Exhibit 7, which is an affidavit filed by the petitioner stating that in the 1970 voter list of 43 number Bongaigaon LEC, her father's name was recorded as Suresh Chandra instead of Suresh Mondal in serial number 96, house number 24 due to bona fide mistake. And accordingly, the petitioner has stated in affidavit that Suresh Mondal and Suresh Chandra are one and same person. Therefore, in the light of such explanation made in the affidavit, Exhibit 7, the Learned Tribunal ought to have taken into account Exhibit 5, 6, and 7 in order to come to a conclusion that opposite party is the daughter of Suresh Mondal. Submission of Learned Counsel for the petitioner is that the discrepancy in the projected father's name of the read petitioner oblique opposite party in the voter list of 2011, Exhibit 5, and the family identity card, Exhibit 6, having been explained through an affidavit, Exhibit 7, by the read petitioner opposite party, the Learned Tribunal ought to have held that the petitioner opposite party has discharged his burden of proof in establishing a linkage with her projected father. We are unable to agree with the submission made on behalf of the read petitioner in this regard. Affidavit Exhibit 7 of the read petitioner opposite party clarifying the discrepancy in her father's name is neither evidence nor proof as per section 1 and 3 of the Indian Evidence Act 1872, read with Order 19, Rule 1 of the Code of Civil Procedure. Such a self-serving suo motu affidavit cannot come to the assistance of the read petitioner oblique opposite party. And
Okay.
Yes, Lordship. And Lordship, as we are here under certiorari jurisdiction, Lordship, that full transfer certificate cannot be accepted at this stage, Lordship.
What about section 6A of the Citizenship Act?
Lordship.
Section 6A of the Citizenship Act. Amended provision.
Amended to not I think it's not a the person of Lordship who falls under minority religion, Lordship, who comes to this territory, Lordship, under religious persecution, Lordship. Lordship, Lordship, just a minute, Lordship.
Yeah.
6B, Lordship, special provisions as to citizenship of persons covered by the provision to clause B of subsection 1 and section 2. The central government or an authority specified by it
You are
in the
reading which one?
Lordship Citizenship Act
Section
Section 6B, Lordship. Special provisions as to citizenship of persons covered by provision to clause B of subsection 1 and section 2 of section 2, Lordship. The central government or an authority specified by it in this behalf may subject to such conditions, restrictions and manner as may be prescribed on an application made in this behalf, grant certificate of registration or certificate of nationalization to a person referred to in the provision to clause B of subsection 1 of section 2. Next, subject to fulfillment of the conditions specified in section 5 or the qualifications for nationalization under the provisions of the third schedule, a person granted the certificate of registration or certificate of nationalization under subsection 1 shall be deemed to be a citizen of India from the date of his entry into India. Lordship, then Lordship, 3. On and from the date of commencement of Citizenship Amendment Act 2019, any proceeding pending against a person under this section in respect of illegal migration or citizenship shall stand abated on conferment of citizenship to him, provided that such person shall not be disqualified for making application for citizenship under this section on the ground that the proceeding is pending against him, and central government or authority specified by it in this behalf shall not reject his application on that ground if he is otherwise found qualified for grant of citizenship under this section, provided further that a person who makes the application for citizenship under this section shall not be deprived of his rights and privileges to which he was entitled on the date of receipt of his application on the ground of making such application. Nothing in this section shall apply to a tribal area of Assam, Meghalaya, Mizoram, or Tripura as included in the sixth schedule to the Constitution and the area covered under the inner line notified under the Bengal Eastern Frontier Regulation 1873. Okay.
New book. Missing. You are relying on section 6B.
Lordship.
Yes, then
And Lordship Foreigners Tribunal Order, Lordship, 1948, 3A, Lordship. Exemption of certain class of foreigners. A persons belonging to minority communities in Afghanistan, Bangladesh, Pakistan, namely Hindus, Sikh, Buddhists, Jain, Parsis, and Christians, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution and entered into India on or before 31st December 2014 without valid documents including passport or other travel documents, and who have been exempted under Rule 4 from the provisions of Rule 3 of the Passport Entry into India Rules 1950 made under Section 3 of the Passport Entry into India
Mr.
Act.
Sharma, just a minute. You are reading which provision?
Foreigners Tribunal Order 1948 3A.
Page number.
Persons belonging to minority communities in Afghanistan, Bangladesh, and Pakistan, namely Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution and entered into India on or before 31st December 2014 without valid documents including passport or other travel documents, and who have been exempted under Rule 4 from the provisions of Rule 3 of the Passport Entry into India Rules 1950 made under Section 3 of the Passport Entry into India Act 1920 with valid.
3A.
Yes, Lordship.
3A 1948.
Yes, Lordship. Yes, sir. Foreigners Order 1948. Lordship. Foreigners Tribunal.
Foreigners order.
Order 1948.
Something is not telling. Foreigners order 1948, right?
Yes, Lord.
Order 3.
3A, Lordship.
3A,
3A
3A,
3A, Lord.
is
exemption of certain class of foreigners.
is 5.
No.
3 capital A.
Yes, Lordship. 3A.
Yes, kindly read.
Persons belonging to minority communities in Afghanistan, Bangladesh, and Pakistan, namely Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution and entered into India on or before 31st December 2014 without valid documents including passport or other travel
You are
documents.
reading from which book?
This book, Lordship.
There is only the power of exempt citizen Commonwealth countries.
No. Lordship, this book. Citizenship Act 9. Foreigners Order 1948. But in this case, Lordship, petitioner
Sorry.
cannot claim benefit of this section, Lordship.
The- Okay, got it. There is not. You can take. Sorry. Yes, Mr. Sharma, you read now. 3A.
Yeah,
It's not applicable.
in
According
this
to
case,
it's not applicable.
not applicable.
Why?
Because petitioner nowhere take this plea before the tribunal that he migrated from specified territory due to religious persecution or due to fear of religious persecution, Lordship. Nowhere mentioned, Lordship. Not a single statement is there, Lordship.
So, whether that plea can be taken at later stage or not?
No, Lordship.
Why?
Lordship, because Lordship, this court is acting under statutory jurisdiction, Lordship. Lordship, para 112 of Muslim Mandal says that, Lordship.
That is 2013, which jail date?
Yes, Lordship. Yes, Lordship.
Muslim Mandal 2013, 2 or 1 3 jail date. About
Full bench decision, Lordship. May I go to Lord? May I read?
what is the citation?
Lordship, 2013, 1 GLT, 2013, 1 GLT 809, Lordship.
Which para?
Para 112.
Yes, state.
Article 226 of the Constitution confers on the High Court power to issue appropriate writ to any person or authority within its territorial jurisdiction. The tribunal constituted under under the 1946 Act read with 1964 order as noticed above is required to discharge the quasi-judicial function. The High Court therefore has the power under Article 226 of the Constitution to issue the writ of certiorari quashing the decision of the tribunal in an appropriate case. The scope of interference with the tribunal's order in exercise of the jurisdiction under Article 226, however, is limited. The writ of certiorari can be issued for correcting the errors of jurisdiction as and when the foreigner court, when an inferior court or tribunal acts without jurisdiction or in excess of it, or fails to exercise it, or if such court or tribunal acts illegally in exercise of its undoubted jurisdiction, or when it decides without giving an opportunity to the parties to be heard or violates the principles of natural justice. The certiorari jurisdiction of the writ court being supervisory and not the appellate jurisdiction, the court cannot review the findings of the fact reached by the inferior court or tribunal. There is, however, an exception to the said general proposition in as much as the writ of certiorari can be issued and the decision of a tribunal on a finding of fact can be interfered with if in recording such a finding the tribunal has acted on evidence which is legally inadmissible or has refused to admit admissible evidence, or if the finding is not supported by any evidence at all, because in such cases such error would amount to an error of law apparent on the face of the record. The other errors of fact, however grave it may be, cannot be corrected by writ court. As noticed above, the judicial review of the order passed by the inferior court or the tribunal in exercise of the jurisdiction under Article 226 of the Constitution is limited to correction of errors apparent on the face of the record, which also takes within its fold a case where statutory authority exercising its discretionary jurisdiction did not take into consideration a relevant fact or renders its decision on wholly irrelevant factors. Hence, the failure of taking into account the relevant fact or the consideration of irrelevant factors which has a bearing on the decision of the inferior court or the tribunal can be a ground of interference of the court or tribunal's decision in exercise of jurisdiction by the High Court. Apart from that, Lordship, our High Court in under case Lordship WBC 1073/2016 Lordship Muhammad Abdul Quddus versus Union of India WBC 1073/2016
WPC 10.
73 of 2016. Para 9 Lordship.
Abdul Quddus.
Yes, Lordship. Para 9.
Just a minute. Para 9.
Yes, Lordship.
Yes, please read.
A careful perusal of the impugn order as extracted above would go to show that the tribunal had appreciated whatever evidence were tendered by the petitioner and thereafter had returned a finding that petitioner was a foreigner who had illegally entered into India, Assam from Bangladesh after 25/3/1971. Thus, a finding based on appreciation of evidence is a finding of fact. Ordinarily, in the writ court would not interfere with such a finding of fact because the jurisdiction exercised is supervisory and not appellate, Lordship.
Okay. Anything you like to cover? Anything else?
Lordship, that's all, Lordship. Otherwise, these cases no merit at all, Lordship. Lordship, in 1965, they annexed 1965 voter list of one Joydev, Lordship, of village Bukulguri. Lordship, that voter list was not exhibited before the tribunal, Lordship. Then, Lordship,
Check the records.
yes, Lordship. Page 14. Lordship. Then suddenly, at the age of 32 years, in the year of 1997, Lordship, Dhananjay Sarkar's name has been appeared, Lordship, in a different place, Lordship, Naherbari. And now, this Dhananjay Sarkar, Lordship, trying to establish his link with a person, namely Joydev Biswas, who executed a cell deed in the year of 1954, Lordship. 1952, Lordship, one from 1952. Again, Joydev Chandra Biswas. One Joydev Chandra Biswas executed a cell deed in the year of 1952, Lordship, and of different village, Lordship. Now this Dhananjay Sarkar of different village is trying to establish his link with that person who is a resident of different village in the year of 1954, Lordship. And this Joydev of 1997, Lordship, Dhananjay Sarkar, son of Joydev, Lordship, 1997 voter list.
Yes.
And this Joydev Biswas of 1952 cell deed, Lordship, list deed, Lordship, cannot be same in one person, Lordship. And petitioner fully failed to establish this link with that Joydev Chandra Biswas, Lordship.
Anything?
That's all, Lordship.
Yes, Mr. Nath, you'd like to supplement anything else further? Whatever Mr. Sharma has stated.
Regarding my lord, the protection under this section 3A, my lord, there is any bar. So, my lord, 226 as the equitable court has the ample power to grant any protection of law if the petitioner is entitled. So on this aspect, my lord, the lordship will consider, and I have nothing more to submit.
What Mr. Sharma. Yes, for the legal copy. Some. Okay. Your name for somebody? Yes, your name has been.
No. For respondent number 4.
Mr. Nath, you have a part hearing in the second half, right? In the second part.
Yes, my lord. Lordship, may Mr. Gogoi is not available. He said that my lord is on lack in some other court. So, my lord, only point is that my lord, Mr. Gogoi said that he will submit some other citation, and maybe taken in another day,
Some other day.
some other day.
No, we have to rise early because there are some interviews.
Yes, Lordship may fix another date.
So kindly give us a date before vacation or after vacation.
Maybe after vacation, my lord.
You give us a date and inform Mr. Gogoi. That's in a single bench, of course.
Single bench matter, single bench matter, madam. Maybe on my lord 7th November. Up to 5th there is vacation.
Inform him on
Yeah,
7th.
I will inform him.
Okay.
Yes, sir. Today is
Okay,
go to look for this of 7th November. She is there, my lord, on behalf of Gogoi. Mr.
You're on behalf of Mr. Gogoi. Inform Mr. Gogoi that that will be taken up in a single bench on 7th of November. Yeah, the single bench are taken up. Mr. Khan, is there anything? Which item?
Item 15, my lord. Can it be around 16 October, my lord.
Lordship, before vacation, some difficulty on my part. So let it be after vacation.
After
It will go after vacation. All these matters will go.
May I please? My lord, regarding item number 7, my lord, may be posted after vacation. Oblige.
Uh, Someone was required to inform Ms. Papiya Chakraborty. I don't know who is appearing for the education. She is no longer in education itself. Do one thing,
নহয় education PGC বিষয় education বিষয় K Gogoi is there as for education
no,
also.
no, that will not be there. Inform Mr. SMT 60. He is now heading the education. This is probably elementary, secondary education. So either Mr. SMT 60 or Mr. Majumdar.
Majumdar is perhaps out of station.
So SMT 60.
I'll call any of the education department
And,
council.
you have to also inform AR Mia. As soon as they come, we'll be back in the. The single bench has to be there. Again, I have to write it for a protest. Just inform Mr. Sisti. Ask Mr. Sisti to be here and ask Mr.
Department losses for losses exemption, and that there's an order for payment of cost in because we didn't file the affidavit. And to recall that order losses, so we have filed this review petition. Though it was filed by earlier council losses, but it was somehow misplaced and we couldn't follow also losses. And we have to contact all the records now. Only for the recalling that order, and in the meantime, losses weeks or 10 days time, I will file a affidavit losses and the matter may
Reviews
be-
for what?
review for recalling that order whereby losses has imposed cost to the then losses at the time secretary.
Why cost was why imposed?
Cost because of affidavit was not filed losses. In fact, instruction was there, but the earlier standing council didn't file that that affidavit. It was not a fault of the respondents actually losses. It is a fault on is our fault of the standing council.
Cost has also not been deposited.
Now we have filed a review. That's why. Otherwise, it is a matter of lordship. They have 2015 advertisement lordship. Whether it is our infractors, actually, lordship. It's a matter.
But there is no such communication between the education department and the concerned council forwarding that instruction.
Yes.
Only stating and absence of probably from knowledge, I believe, that particular.
But if I remember, I have seen that instruction, Lordship, but the earlier councillors who has handled this case, Lordship, I don't know. I'll have to find it again, Lordship. But I have seen that instruction, Lordship, that I remember, Lordship. The instruction was there, but they didn't file it.
Part Mr. SMP Sestil, learned counsel appearing for the petitioner. What's your good name?
N.A. Majarpuria.
Learned counsel for the party / review petitioners. Sorry, read petition. The respondent. The opposite party as read petitioner filed a connected WPC number 7099 of 2015. Praying amongst others. The notification number DME .491 public AP APPWT public 2010 public part of PT yes capital Roman 1 oblique A 17/09/2015 issued by the state government, issued by the Directorate of Madrasa Education Assam as it was then. Specifying the criteria for selection of the eligibility and qualification for various posts like lecturer in case of title madrasas public Arabic colleges, assistant teacher, FM assistant teacher, assistant teacher for theological subjects in senior madrasas and Arabic colleges. FM assistant teacher, FM assistant teacher within senior section, bracket close, for senior section to bracket for theological subjects in senior madrasas in Arabic colleges. FM assistant teacher within bracket pre-senior section, bracket close, for theological subjects and academic. Assistant teachers H.S. within bracket pre-senior section in senior madrasas and Arabic colleges. Assistant teacher Hindi within bracket graduate for senior section in senior madrasas of Arabic colleges. Assistant teacher Assamese within bracket only for Borak Valley, bracket close, for senior section in senior madrasas / Arabic colleges. It was circulated by the Director of Madrasa Education to all the superintendents of concerned title madrasas, Arabic colleges. Principal really title madrasas and other madrasa education. So notice in that case, in say WPC number 7099 of 2015 was issued on 23/11/2015. But that stay order is still in force, Mr. Sisi, or the selection process was stayed. Selection was made, but was directed not to finalize the selection process. Don't know what happened. Of course, that stay order is until further on. What happened? But the respondents in the education department, concerned education department did not file any affidavit in the matter. As such, the court, by order dated 15/02/2021, while granting time to the respondents in the education department on their prayer, as it failed to file its affidavit, within the time so specified by order dated 19/01/2021, i.e. up to 02/02/2021. The court accordingly, but the said order dated 15/02/2021 impose cost, directing the Commissioner Secretary Government of Assam in the Secondary Education Department, comma, the Director of Secondary Education Assam and the Joint Secretary to Secondary Education Assam, the concerned authorities who look after the matters of provincialized madrasas in the state of Assam, directing them to pay rupees 25,000 each from their salary towards the cost by depositing the same in the Legal Service Authority of the High Court on or before 04/03/2021, obtaining necessary details. In this review petition, the applicants stated that applicants by swearing an affidavit clearly stated, specifically stated that they admitted the lapse on their part in filing the affidavit within time, but admitted but specified that after the order of the court on 19/01/2021, on 29/01/2021, instruction was furnished to the standing council enabling the concerned council to enabling the council to file its affidavit in the matter, enabling the conducting council, and the said fact could not be placed by the concerned conducting council before the court on 15/02/2021. Before the court, for which the court by the said order dated 15/02/2021 imposed cause as noted above. It is also been placed before the court that on the basis of the said instruction issued earlier on 29/01/2021, the applicants, i.e. the respondent authorities in the education department on 12/03/2021 filed its affidavit in say WPC number 7099/2015 as the court by order dated 15/02/2021 and 10/03/2021 granted time to respond to the time to the education department. Admittedly, on next period of 15/02/2021, the fact that the education department on 29/01/2021 furnished the relevant instruction to the concerned conducting furnished the suspension was not placed before the court by the concerned practice. After hearing the parties and considering it, the order of imposition of cost of rupees 25,000 each on their salary. And the salary 25,000 each. From the commissioner, there is a comment of some. Secretary. Yeah. Order to that. The order is 15. First, this order shall be the order 15-0 to first paragraph. Therefore,
May I please your lordship? Lordship, actually my senior supposed to attend today, but he could not come today to the court, your lordship. He felt unwell, so he left the court again. Your lordship may allow me to submit only 2 aspects for the review, your lordship.
who is for the other side? Notice have been issued or not? Okay. Which order to be reviewed?
Lordship, page 63, your lordship. Order dated 15/3/2023. Of effective part, your lordship.
Just watch what is the wrong.
Page 66, your lordship, last para. May I read, your lordship?
Just a minute. Page 66.
Page 66, last. May I read, your lordship?
Yes, yes.
In the case in hand, the petitioner failed to place the numbers of enrollment of the students in the said Biraj Mohan Kumudini Datta ME School as per the data record in Dice Code of 2009-10 or before, requiring provincialization of an additional teacher in the said Biraj Mohan Kumudini Datta ME School at the relevant point of time. Your lordship may kindly come to page number 44, your lordship. DSC report, your lordship. Here, your lordship, age. Whether the enrollment shall be verified with the date as per Dice Code 2009-10 or before as available in the records of NUEPA, New Delhi, section 3.1.12. That is yes, your lordship. Lordship, already the complete set of Dice Code was submitted to the respondent authorities, your lordship. We, in the earlier round of litigation, we also annexed the incomplete Dice Code, your lordship, which we have again annexed in page 68, your lordship. 69. 68 and 69 is showing the name of the petitioner, your lordship. Gulnehar Begum. In the code of language teacher, your lordship. So, your lordship, if Dice Code could be called for by the respondent authorities, because these are all already this Dice Code has been submitted to them, your lordship.
Just a minute. Just a minute. What's your good name?
Ide Mario.
For the petition. And Mr. Department. The review petitioner as a writ petitioner referred connected WPC number 1347 of the 2023 was disposed of by order dated 15/03/2023 finding that the petitioner failed to place the numbers of enrollment of students in Viraj Mohan Kumudini Dr. ME School as per the data recorded in Dice Code of 2009-10 or before, requiring provincialization of an additional teacher in said Viraj Mohan Kumudini in the said ME School at the relevant point of time. And accordingly did not interfere with the impugned order, impugned speaking order, impugned order, period 19/11/2022. Passed by the Director Relevant Education Assam in compliance of the order dated 16/09/2021 passed in application number 4670 of 2021. It was preferred by the petitioner. It's a notice. That's happened. That's no problem. Please count. Seventeenth of October. Will dispose of
Oblige, Your Lordship.
17th of